Good afternoon, ladies and gentlemen, and welcome to today's webinar brought to you by myself, Nicholas Kisson. We have muted everyone's phone, but feel free to send in questions. You can type in questions in the chat box on the right-hand side of your screen, and I propose to take any questions at the end of the webinar, which is scheduled to last about half an hour, 30 minutes. Right, I shall read to you the disclaimer that's on the screen. Whilst we make reasonable efforts to ensure our content is accurate and up to date, information and guidance in this webinar does not and is not intended to amount to legal advice in any particular case. No responsibility for any consequence of relying upon the webinar material or presentations of the webinar is assumed by Lease, Leasehold Advisory Service or Lease Conferences, or any of our advisors. The law is correct and up to date as at today's date, Wednesday, 5th of November 2014. And that's our topic for today. Phillips and Goddard against Francis. Hot off the press, the recent Court of Appeal judgment. And that's the long title of the judgment. We've known it so far, those who have become very familiar with the case, as Phillips and Francis. There's two Phillips and Francis judgments, number one, Phillips and Francis, and number two. But we've been mainly concerned with the High Court one, Phillips and Francis number two. But the roles are reversed on the appeal by the landlords, and that's the long title. Francis another, Mr. and Mrs. Francis against Phillips and another, Royner Goddard. They were suing on behalf of themselves and other owners of 97 holiday chalets at Atlantic Bays Holiday Park, formerly called Point Curlew in St Mirren, Padstow, Cornwall. And the Secretary of State for Communities and Local Government intervened. I shall explain why later. The hearing took place mid-October, 14th of October, for one day. Judgment was announced, or shall we say, it is dated, it bears the date of 28th of October, but it wasn't formally handed down and made public until the end of October, 31st of October 2014. The judgment was essentially about two issues. One of them was about the recoverability of management charges. That particular issue was very much fact and lease dependent and is not going to be covered by myself in this brief webinar today. But what we shall be dealing with, and the law that does concern us, is as on the screen, what's called consultation. Consultation for major works, which can be found in sections 20 and 20ZA of the Landlord and Tenant Act 1985, which were to a considerable extent amended by the 2002 Commonhold and Leasehold Reform Act. The Landlord and Tenant Act 85, sections 20 and 20ZA, set the broad framework. But the devil's in the detail with consultation requirements, and that detail for England can be found in the consultation requirements in 2003, and for Wales in the consultation requirements that came in 2004. Essentially, Section 20 of the 85 Act limits the ability to recover service charge costs in respect of qualifying works from residential tenants or leaseholders, unless a consultation procedure in a prescribed form has been followed or a dispensation order granted by the appropriate tribunal. In England, the appropriate tribunal is the first-tier tribunal property chamber, and in Wales, it's the Leasehold Valuation Tribunal. Qualifying works are defined as works on a building or any other premises, essentially like roof repairs, external repairs, decoration, etc. And that's the basic definition that lies in the legislation. It applies where those costs of repair or maintenance or improvement on the qualifying works exceed an appropriate amount. So where any one flat or leasehold house perhaps on an estate, is being called upon to pay more than £250 towards the cost of those works, then the consultation process kicks in, or a dispensation order should be sought from the appropriate tribunal. And I'll explain in a moment what the sanction is if it's not followed. The generally understood view of what qualifying works meant basically goes back to a Court of Appeal case, Martin and Mary Land Estates Limited, in 1999, where it addressed the meaning of qualifying works in the landscape before the changes made by the 2002 Common Hold and Leasehold Reform Act. Essentially, it applied the set test and regarded the £250 as what they called a triviality threshold. So one looked at individual sets or individual projects, discrete particular aspects of works within a series of works. It might be one single set of works or a series of sets of works, but one looked at an individual set of works and then decided whether the costs incurred towards that particular set exceeded £250 per premises, in which case the consultation process requirements kicked in. Now, the sanction is a financial one, which I shall come to in a second, but if the appropriate amounts exceeded, consultation process has to be followed or a dispensation order sought from the appropriate tribunal. The consultation process, in a nutshell, involves service of certain notices with certain information on them, giving a chance to make observations upon the information in those notices, broadly information in the first notice about the intended works, and in the second notice about the intended costs set out in estimates. And if a contract's awarded, then in certain circumstances, save with certain exceptions, a notice has to be sent out to the leaseholders stating that that contract's been awarded and the reasons why. When it comes to seeking dispensation from consultation, the application, as I said, is made to the appropriate tribunal, and the test is that the tribunal has to be satisfied it's reasonable to dispense with some or all of the requirements before they'd be prepared to make a dispensation order. So if one fails, the landlord or manager fails to consult or obtain dispensation, the sanction is a financial one, namely the service charge contribution of the leaseholder towards those qualifying works is capped at £250. So it was a block of 10 flats, all paying service charges. It's going to be, they can't recover more than £2,500 in all. And if it's a huge project with huge costs, one can only speculate about what a big difference that will make to the landlord's finances. Now, on to Phillips and Francis, or should we now call it Francis and Phillips and others. It all started with the location over in St Mirren. It was a disused WW2, World War II airbase. Essentially, a 25-acre holiday site had been created in the 1970s from this disused airbase, on which, among other items, there was over 150 chalets on 199-year leases. The freehold was sold to Mr. and Mrs. Francis in April 2008, who then went on to announce at a meeting with the chalet owners of their intention to bring the site up to a first-class standard from which they might all benefit. That meeting being in May 2008, and of course followed with letters to the owners in mid-May 2008. This had an impact on the service charges. The last service charge before the sale to Mr. and Mrs. Francis had been round about £1,400 per chalet owner, and the first demand after the sale was around about £3,100, so doubled plus. Yearly accounts subsequently were rendered referable to the 2 years when the works were carried out, and as one can see from the slide on the screen, that for most of the year ending 2008 and 2009, they were either over £250,000 overall, the recoverable charges, and also over £500,000, and that included the qualifying works. The litigation kicked off in February 2009 when the chalet owners issued proceedings in the High Court. And what they sought were declarations as to the recoverability of service charges and injunctions as to restraining potential forfeiture proceedings should the service charges not be paid. There was at Phillips and Francis judgment number 1 a decision that was the outcome of arguments upon whether the particular holiday chalets on 999-year leases were classified as dwellings. If they were classified as dwellings, then the 1985 Act would apply, and then should they apply, consultation might have to be followed. And the High Court Truro District Registry decided that those chalets were dwellings and attracted the protection of the 85 Act. Matters were then transferred to the County Court, and after a 6-day hearing, judgment was handed down on the 19th of March 2012. I think that might be 2010. There was no consultation under Section 20 for service charges demanded for 2008 and 2009. That was common ground. There probably wasn't consultation because they didn't think they were dwellings and didn't attract the Section 20 provisions of the 85 Act. It was common ground, again for the same reasons, that no dispensation order had been sought and obtained from the appropriate tribunal. And it was common ground that the service charge contribution sought from each leaseholder in respect of the works exceeded £250. Now, what did the owners argue at the County Court hearing? Well, the chalet owners argued that all those works should be looked at as planned as a single set of works, and therefore there should have been Section 20 consultation, and accordingly each owner should not have to pay more than £250 each towards the cost of the works. What did the landlords argue, Mr. and Mrs. Francis? Well, they they argued along the Martin and Maryland lines that they were separate individual sets, projects of work undertaken in a piecemeal fashion, presumably as finances allowed, and that as none of those individual sets or projects led to any one chalet owner being liable for over £250 towards the cost of those works, the obligation to comply with Section 20 consultation had never arisen. The County Court's approach was along Martin and Maryland's lines to identify individual sets of works, such as external decorations one set, roof repairs another set, and to then decide whether the costs are going to be over £250 from any one leaseholder, referable to the individual sets of works. What did the County Court decide? Well, the County Court decided that Section 20 consultation need not be followed, and they decided that looked at individually. There was no single set of qualifying works. There were separate sets, discrete sets or projects of individual works, and looked at, they did not attract the Section 20 procedure, and therefore consultation did not apply. The leaseholders appealed, and a judgment was eventually handed down by the High Court Chancery Division just before Christmas 2012, 21st of December. Judgment by Sir Andrew Morritt. It was his last judgment before he retired, and he was the Chancellor of the High Court at the time. And what did the High Court decide? They found in favour of the chalet owners. They said that Section 20 procedure applied and should have been followed. Now, what was controversial about this particular judgment is the reasons why the Chancellor decided that Section 20 should be followed. In his view, the approach was not looking at sets, but what has been described as the aggregating approach, bringing all the works together. All the works are qualifying works for the purposes of Section 20. And to quote his judgment, I see nothing in the present legislation, which was then the 2002 Act and still is, which requires looking at and identifying one or more sets of qualifying works. And it's down to the landlord to assess whether the works are going to be on such a scale as to necessitate complying with the consultation requirements or face the consequences if they don't. And as the contributions are payable on an annual basis, one looks at the qualifying works throughout the year. So one looks at works of repair and maintenance, however small, reactive, unplanned, throughout the year. You top them all up at the end of the year, because he said it's going to be on an annual basis, and if the total cost of those works means that any one leaseholder is going to have to pay more than £250, then Section 20 would apply. Accordingly, the aggregating approach meant that there would be no distinction between different sets of works or projects, and rather than looking at major works or projects, one looks at the whole throughout the year. These particular works straddle 2 service charge years, as you've seen from the accounts earlier, and therefore one looked at it throughout the year. It was subject, as I said, to a lot of controversy about whether or not, essentially, it made consultation unworkable. And eventually an appeal was made and permission was given out of time to appeal to the Court of Appeal, where it came before at the hearing earlier last month, October, before the Master of the Rolls, the head of the Civil Court Appeal Division, the Civil Division of the Appeal Court, the Chancellor of the High Court, who was actually, you'll recall that the previous Chancellor heard the High Court judgment, and it was the Chancellor of the High Court, the present one, sitting in at the Court of Appeal, and another Lord Justice Kitchen. The Secretary of State for Department of Communities and Local Government also intervened. They intervened because they considered that there was a question of statutory interpretation of public importance with the potential to affect large number of residential landlords and tenants throughout the country. And what did the court decide? Well, the Master of the Rolls and the Chancellor of the High Court and the Lord Justice Kitchen, they were all at one. There was no dissenting judgment, and the Master of the Rolls was essentially giving the leading judgment. To quote, he said that it is not a sensible approach and gives rise to serious problems, practical problems. It cannot therefore have been intended by Parliament. And to quote from paragraph 26 of the judgment, it requires that at the very latest, or at the very least, once the limit for contributions has been reached, £250 per leaseholder, the landlord must consult the tenants on any service charge items, however small they may be, presumably subject only to the de minimis exception. Mr. Seitler, that was the barrister for the landlords, he illustrates the problem with the following example. Imagine a residential block of flats with 4 tenants. The annual regulatory limit is 4 times £250, that is £1,000. 3 lots of minor works on a building, each costing £75, are carried out in the first half of the year. The landlord has therefore spent £225 on service charge items, and there's been no consultation. Unexpectedly, in September, the outer door of the block breaks, and a new door frame is required, which would cost £800. A storm in November causes window damage that would cost £1,200 to repair. On the sets approach, the landlord would not need to consult on any of these items. They are all distinct sets of qualifying works, none of which costs more than £1,000. The landlord could respond immediately and repair the damage to the door and the window. On the aggregating approach, and this is paragraph 27, the annual limit is exceeded by the broken door. The landlord is obliged to consult on it. This process takes time and costs money. If instead he replaces the door immediately, he has no right to recover the full cost without dispensation. Seeking dispensation has attendant legal and administrative costs, as well as the risk of non-recovery and delay. But if he does not replace the door, the flats are unsafe, and he is likely to have irate tenants. And essentially, the court felt that the added administrative burden brought about by the aggregating approach must increase costs for landlords, likely to be recoverable under the terms of the lease. If they are recoverable, the tenants will have to pay for the protection of consultation, even on minor matters. And the court said, the Master of the Roll said at paragraph 28, I do not consider that this can have been intended by Parliament. The court also stated that the legislation itself doesn't talk about slicing the works up into individual years. In other words, there's no mention of an annual cap. The Court of Appeal said that the sensible way to control routine works of repair and maintenance, which were unlikely to be the subject of a detailed plan in advance, was through the requirements in Section 19 of the 1985 Act that all service charges should be reasonable and reasonably incurred. So if a leaseholder is dissatisfied with works of repair and maintenance, that they might not have attracted consultation under the sets approach, they can still be challenged at the appropriate tribunal if a case can be made out that their costs not reasonable or reasonably incurred. So the status quo was restored. The Court of Appeal said the correct approach was to apply the cap by reference to individual sets of work, not the aggregating approach. And the court also gave guidance, the Court of Appeal, on what exactly is a single set of qualifying works to identify among a number of sets of works. They said it's a multifactorial question to be answered in a common sense way, taking into account all relevant circumstances. And that the relevant factors are likely to include where the items of work are to be carried out, and it goes on to say whether they are contiguous to or physically far removed from each other. So I suppose the closer the works are, the items of work are to each other, the more likely there are to be one single set. Whether they are the subject of the same contract, so if they are, more likely to be a single set. Whether they are to be done at more or less the same or at different times. So if they are being done around about the same time, more likely to be a single set. And whether the items of work are different in character from or have no connection with each other. So if they're of like character or have some connection, more likely to be part of a single set. And it goes on to state that the list there is not intended to be exhaustive, and that the matter is ultimately a question of fact and degree. The Court of Appeal also added that there is actually no requirement that the work itself, and this is at paragraph 38 of the judgment, that to be classified as qualifying works, there's no requirement that the works have any permanent effect modifying what is already there. So looking at the particular intended works had gone on at St Mary, the county court, in the Court of Appeal's view, was entitled to find that at least until 2009, that the work planned and carried out was not part of a single set of works, and that it was essentially that the judge had inspected the site, looked at all the evidence, that the facts were supported by the evidence, and the appeal court couldn't interfere, and that the landlords were entitled to undertake the work in such sequence and such manner as they chose, so long as they complied with their contractual obligations. And they concluded that the judge had properly addressed the question, which was an objective one, of whether the work constituted a single or multiple set of qualifying works. The appeal by the landlords was allowed and the county court decision restored. So what one takes away from that is that it's the sets approach that is applied. One looks at each individual set of works and decides whether the cost of that set of works, once identified, will lead to any one leaseholder having to pay more than £250 towards the costs involved, in which case consultation must be sought or a dispensation order from the appropriate tribunal, or else the financial sanction applies and not more than £250 can be recovered from any affected leaseholder. And there is also, as you could see earlier, guidance was given as to how one identifies a single set of works. So that's a brief overview of the recent Court of Appeal judgment in Phillips and Francis. Just like to mention, we've got some webinars coming up, including one on Section 20. I'm going to be giving a webinar on the 20th of November, which is going to be a detailed look at the Section 20 requirements, including seeking dispensation from the tribunal. It will include the impact of the Court of Appeal decision, because it does explain the philosophy to a certain extent that informs Section 20. I'll also be covering the Supreme Court judgment of early last year in Dejan and Benson, other pertinent case law, and touching on things like framework agreements. And there's, as I said, there's other webinars coming up and classroom training. So that looks like dead on half an hour, and I'm now going to ask if you've got any questions. Okay, somebody's asked, possibly an issue for your next webinar, but who pays the cost of consultation? Well, it depends on the terms of the lease, but it usually tends to be the leaseholders, and it might be there's a particular aspect of the management fees or an add-on to the management fees, and that was one reason why the courts are unhappy with the Court of Appeals unhappy with the aggregating approach, because the work involved in consulting on just all sorts of works, however minor, would mean additional costs ultimately loaded onto the service charge payers. Right, here's an interesting one. Where a Section 20 consultation has already begun, for qualifying works on an aggregated basis, including routine and reactive maintenance, pre the Court of Appeal judgment and notice of intention has been submitted, will it be necessary to complete the consultation with statement of estimates, etc.? The short answer is I'm not certain, but I suppose to be on the safe side, perhaps one ought to. It's an interesting one. Definitely, as I said, I think to be on the safe side, it might be better just to serve the statement of estimate, particularly as it might be the expectation of the leaseholders they get such a statement of estimates now they've had the notice of intention. Does insurance payment per household, £270, should be consulted with leaseholders? Well, this case was, of course, about major works, and an insurance payment is not a major work. I suppose consultation for insurance would be necessary if the insurance contract was under a qualifying long-term agreement, but these qualifying long-term, insurance policies tend to be for a year and no more, and a QLTA is for no more than 12 months. Does this apply to services as well as work, such as cleaning or communal electricity costs? I think I may well have addressed that in my previous answer, but this case was about qualifying works, not about services. Services are the subject of consultation or an application to the appropriate tribunal for dispensation, where those services are going to be the subject of a qualifying long-term agreement. The questions are coming in thick and fast. We are part of a residential commercial block comprising 6 shops and 9 apartments. Are we liable to contribute to the fire alarm system that is deemed necessary to comply under fire regs? I'm not sure that's really relevant to, with all respects to the questioner, to the particular webinar today. But what I'm doing is I'm happy to discuss it offline. Also, those I haven't managed to get round to dealing with in the time available, because there are a lot of questions coming in. Can you enter into a QLTA consultation in order to avoid consultation? Probably not now. I mean, what there had been is when the High Court judgment was handed down and that whole aggregated approach causing controversy, one of the possible ways forward was do a QLTA at the beginning and then consult throughout the year. QLTA is more familiar in the public sector sphere. Have a look. If a landlord tries to impose a 50% increase in a service charge for repair works that should have been done after a fire, do they have to issue a Section 20 consultation as the amount due from each payment is way over £250 per owner? That's more of an issue really when it was the aggregating approach rather than the particular approach now. The approach now is just looking at it as the set of works, identifying the set of works. Is the 50% increase part of the set of works? Let's see. Can you clarify, please, then, that the landlord is allowed to complete piecemeal jobs under one umbrella and expect residents to comply? And is this only to be within a two-year period? Well, piecemeal jobs, it really reintroduces the concept of the triviality threshold, and that the piecemeal jobs, if they are of a low cost, are not really going to be consulted upon, because it would only make sense to consult upon them if it was still the scenario of the High Court judgment. Now one looks at is it part of a set of works? If it's all part of a set of works, and that set identified and using those factors that were mentioned, although not exhaustive, by the Master of the Rolls, if they lead to any one leaseholder paying more than £250 towards that set as identified, then it may well be that the consultation will have to be followed. Right, some long questions here. We are an informal residence, presumably residence management or residence committee, managing 6 flats. Is it reasonable to recover the cost of admin of Section 20 consultations from the service charge account? Again, it really depends on the lease. If the lease provides for recovery of costs of management, possibly it does. But something I'm happy to discuss online and happy to look at any particular authorities and to come back to you on that. Another question, difference between needed urgent repair and improvements. I think I was looking there for a distinction between repair and improvements. That, with all respect to the question, it's not the subject of my webinar today, but it's something I'm happy to discuss online, and I'll keep details of questions I've been asked and happy to come back to people. What if no consultation is carried out because cost is less than £250, but partway through the works, additional works are found to be required, increasing the cost to more than £250? Would this be considered part of the same set of works? Might be. My recollection is that that's very similar to the Martin and Maryland scenario, and it might, if it's all going to be part of the same set of works, the additional works, then it would attract consultation requirements, or else seek a dispensation order from the tribunal. Someone's a really long question here, but I'll try to deal with it. I have a development of mixed units consisting of freehold and leasehold. This is relevant mostly to the leasehold units, given the lease requirement to decorate or redecorate. We start the consultation period to carry out external decorations, inclusive of a preparation of a scope of works for the entire development project. We propose to carry out the project in stages over 3 years, 3 stages. We appoint a surveyor to administer the contract, presumably a contract administrator, the work for stage 1 of the 3 stages. We obtain tenders following the consultation to the required stage 2 and start the works. Do we need to start the consultation from scratch for the 2nd stage at year 2? The works are a separate works contract, as each are put out to tender in stages, but the consultation and correspondence have been transparent that this will be a 3-stage project. I wonder if the author's happy for me to, it's quite a complex question, I'm happy to come back and discuss that with them offline and to explore it with them. I can see that the Court of Appeal judgment is certainly generating a lot of food for thought. Are you saying that if the works can be shown to be emergency and above the £250 threshold, that the works can be carried out without consultation? In our building with some 50 flats, this is always a high threshold anyway. Well, it really goes back to whether the works themselves are all going to be part of the same project. There's a triviality threshold. You're not expected to consult on every single aspect of the works, but only those that meet the requirement for qualifying works. If they are going to meet the requirement for qualifying works and it's an emergency, the tribunals, the appropriate tribunals, tend to give dispensation. That's been my experience. As long as they're persuaded that it's emergency work, particularly if there's a health and safety issue, then they tend to give dispensation. What is classified as a reasonable increase in service charge? Our freeholder, well, I won't mention their names, provides a poor property management company called, won't mention their names either, which did not arrange any sinking funds nor services put in the lease. The property was renovated 2 years ago, and now we have found issues with the roof, resulting in £30,000 cost to repair, as well as leaking into attic flat. The management company has now been changed, but the service charge is 50% higher, due to previous management company providing extremely low number but no real services. The new management company seems reasonable. This increase in cost as well as repair costs is dramatic. Is this reasonable? Well, that's not quite, in all respects, the writer. It's not quite the subject, reasonableness of costs, whether they're reasonable, that I'm covering today. But I can certainly, offline, go through the various aspects of what is reasonable, or what is understood as reasonable, and how reasonableness is approached, should, and hopefully it doesn't, should it ever end up at the appropriate tribunal. Somebody's asked what number can I speak to offline. If you can email and or ring that number and leave a message with reception. But what I'm happy to do is I'm happy to gather up contact details, because we've got your email addresses, and to get in contact with you or ring you directly. Right, if an individual leaseholder doesn't respond or make any written observations to any of the consultation notices, do we proceed based on the responses from the remaining 5? Well, I mean, the point about the observations is you're not bound to follow what's in the observations. You're only required to have regard to any observations put in within the relevant period, namely 30 days from service of the notice. But it's good form anyway to at least have a look at any observations that are made outside the 30-day relevant period, to at least, if they're meaningful observations with some forceful points, to take them on board, albeit the statutory obligation to have regard to them wouldn't apply. And somebody's given me their phone number. Let's see if any I've missed out. Issue for your next webinar: who pays the cost of consultation? Well, I'll bear that in mind when designing the next webinar, which, as I said, is on the 20th of November. On section 20. Well, somebody's written, I think with reference to presumably the facts and issues in the Phillips and Francis case. So it seems this was to do with works emerging as time goes. What about works that are already accumulated? Can they be treated as separate sets of works? Well, you have to look at the works, the whole project, whole collection of works, looking back and then applying the test, although set out by the master of the rolls, which I said the factors weren't exhausted, but looking at those factors and then deciding are they a separate set of works. I suppose that may well be that the Court of Appeals has introduced another controversy about identifying separate sets of works, but all I can say is that the aggregating approach doesn't apply anymore. Are we able to purchase this presentation for reference in the future? Well, it will be made available. There's no need to purchase it. Right, see, another 10 minutes or so to go. And let me just see if there's any more questions. There's a question. The FTPC, presumably that's the First Tier Tribunal Property Chamber, determined that the freeholder had issued a long-term agreement without consultation. Therefore, the maximum only one leaseholder has to pay for the 5 years the contract covered. Does the amount permitted by the FTPC still have to be supported by invoices or receipts? Well, I'm not sure that's quite relevant to the topic of our webinar today. But what I can do is, happy to discuss that with you offline. It's a question I'd like to clarify with the person offline, but it says a total cost. So a total cost of £250 each for 4 tenants it is £1,000, correct? But if the lease limits 2 flats to 12.5% charge each and 2 to 75% between them, does £250 each be limited by the relevant percentages? Well, the fact is they're not. If the percentage or apportionment of the service charge means that they'd be paying less than £250 anyway, then that lesser amount is the amount that they pay. So anybody who ultimately will have to pay less than £250 is not going to start having to pay £250, but nothing more. But what it means that those who would have been paying more than £250, where Section 20 applies, will not be required to pay more than £250 unless consultation has been followed or a dispensation order granted by the appropriate tribunal. It seems from what you say that the freeholders had an intention to modernise, upgrade as a programme, albeit in stages. Is this not very close to a single project? Well, the Court of Appeal said, well, we looked at the, we looked at it. We rely on the county court, what the county court did. We're fixed really by the facts found by the county court, as was the High Court, and looking at those facts and the relevant law being the sets approach and applying the law to those facts, we find that we've identified that there was not one single project or single set as the leaseholders contended, and that there were, if anything, distinct sets that could be identified, but the consultation didn't apply, and that it wasn't really until because the work, it was done as and when, it was done in a piecemeal fashion, presumably as when funding was made available, and applying the test, they couldn't find that it was set test that they couldn't see that there was a single project envisaged from the outset. And to quote again, that the landlords were entitled to undertake work in such sequence and such manner as they chose, so long as they complied with their contractual obligations. I'd recommend for those who are going to look at the judgment, reading paragraphs 34, or paragraph 34 that deals with the county court conclusions about the, it was on his Judge Cotter's conclusions, the county court, and their approach, as it gives a description of the project. I have recently challenged service charge increases where consultation did not take place, and my landlord limited my cost to £100. Where other residents did not challenge these increases, can the landlord charge them the full increase? Well, I suppose they could, but the fact is, if they got wise to it, they could challenge the landlord and say, we're not paying anything more, and that's the extent of our obligation. I think that, I don't know whether this was a tribunal decision or just a challenge that you made and they conceded. It was a tribunal decision, and the tribunal decision is applicable only to the parties named on the decision, and the other residents may not be parties named on the decision. But the fact of the matter is that if consultation hasn't followed, then none of the parties can pay more than the appropriate amount, or called upon to pay the appropriate amount. You mentioned cost limited to £100, so I take it that means that it was a part of a qualifying long-term agreement. Would you make a general comment on the definition of qualifying works and whether they should really only encompass major works contrasted with routine maintenance? I'm a bit loath to make general comments because I'm really here just to advise on what the law is. The law doesn't, the legislation doesn't, gives a definition of qualifying works as I mentioned in the earlier slide, works on a building or any other premises. But consultation in respect of qualifying works only kicks in if the sets approach is applied and that one can identify a single set towards which the costs involved will entail one leaseholder having to pay more than £250. If routine maintenance, the idea is there's going to be a triviality threshold, and that routine, if the costs involved themselves, routine maintenance are not going to involve anybody carrying out, having to pay more than £250. It was like £150 for minor work or small drains repair, spread among a load of leaseholders. That's not going to involve consultation. And if it's if it's set apart from others, there's other routine maintenance later on, that's not going to need consultation upon, and that demonstrates that the aggregating approach has been overturned. So, but the actual major works is spoken about as consultation for major works. Major works is not a term used in the legislation, but it's been understood. I suppose it's the phraseology that's come about because of the triviality threshold approach from Lord Justice Robert Walker in the Court of Appeal decision judgment in Martin and Maryland, that it's only looking at the proper projects, major works really, because it's just not really cost effective to consult and wouldn't have been the intention of the legislation. If a landlord refuses to provide copies of invoices for service charges, can a leaseholder refuse to pay? That's not really part of our debate today, but I'm happy to discuss that offline, and I can answer it, but I'll answer it offline. For neighbouring, well, I think we're nearly coming to the end now. What I did is they're coming in again, a few ones, including whether such and such is a qualifying long-term agreement, or is it services or qualifying work. I shall deal with those offline, but I'm going to bring this webinar to an end now. What I'd like to say is thank you very much for being a terrific audience, and thank you very much for large number of challenging questions.